That's right, you are listening to Solihull Radio. It is #Legal Hour. It's just after 7 o'clock here on Tuesday Thoughts. Joining me in the studio, a fantastic team of solicitors who have wandered across from Thursfields Solicitors here in central Solihull. Good evening, gentlemen. How are you?
Good evening,
Geoff.
Yeah, there's three of them sitting the other side of the table. I feel a little bit overwhelmed, if I'm honest. Right, joining me with a specialism in wills and probate, of course, it's Edward. How have you been since we last spoke?
Very good, thank you. Happy New Year, I think, in order.
Absolutely, yeah.
Belated.
We didn't see each other, did we, for last legal hour? So Ed's specialism is wills and probate. Anything along those lines, any questions that you've got for Edward, by all means get in touch with us here, studio@solihullradio.com. You can text your legal questions to Ed, 075 64 30 30 64, or of course you can give us a call and you can actually chat to him. It might be a bit tricky, actually, because I haven't thought that bit through yet, but I'll work that out in a minute. And sitting next to Ed is Phil. Now, Phil is a family law specialist, so anything family-related, you can get in touch using the same methods. And sitting next to Phil is the fantastic Stephen. Now, Stephen is a very chilled-out solicitor. He is here to help you resolve any disputes. So if you have any problems with other people or the sort of fine print of things, he is your solicitor of choice. So 3 different specialisms this evening. We've got some questions. We're going to start having some chats. If there's anything or you want us to take the chat in a certain direction, just get in touch with us and we're happy to do that, especially for the podcast element of the show. Right then, gents, what's new in that fast-paced world of law that you guys live in most days? What's happening in 20 or so? End of next month. We're going to be looking at completely different things, aren't we? What's it looking like in law terms for you? Oh, all go at once. Go on. Well, what's it looking like?
The honest answer, Geoff, is I don't think we all know yet. Certainly from a family law perspective, most of the laws will, if not all of the laws, will stay the same. There'll be some issues with regards to jurisdictional issues for us, for dealing perhaps with children who are going abroad or having reciprocal arrangements with countries in Europe. It's going to be interesting to see what happens after deadline day with that. But to all intents, most of the law in family is going to stay the same.
And Ed, they're not changing any of the laws. If you've got property, for instance, that has been left in wills, will that change after March?
I think at the moment there's nothing sort of obvious on the cards. I don't think it's going to be one of those cases to see what actually happens, but I think as things stand at the moment, we're just sort of keeping calm and carrying on.
Okay.
You mentioned about the end of March, and obviously you're talking about Brexit, but in my world, one thing that is happening is we've got an increase in probate fees, a quite significant increase, which looks like it's probably going to come in April.
Right.
It's still got to be voted through in the House of Commons, but obviously they're up to some of the business at the moment, so finding time for that. But that's going to have an impact. But again, the finer details of that are still to come out in the wash.
Okay, right. And do you happen to know the difference in percentage of the fees? Is it quite substantial? Or?
Yeah. So at the moment, you've got a flat fee. If you apply through a solicitor, it's about £155.
Okay.
And what they're going to go to is a sliding scale based on the value of the estate. So a lot of estates that are of lower value, they're going to remove the fee completely. If it's under, I think, £50,000, and then you've got a sliding scale up to, when you're talking £1 million or so, it could be £6,000, I think, at the top end. So
wow,
big change.
So moving from £155 right up there, yeah, that is a massive percentage increase.
Yeah.
Right, and Stephen, anything that's coming your way in terms of the legal papers? Have you seen any articles or read any papers that are changing?
I'd say there's been a lot of future gazing from the law firms with commentary on what may happen with Brexit, how best to protect against Brexit. From a dispute resolution point of view, I think sort of the majority of the work that I do certainly is very domestic. So it'll be disputes involving contracts based on an English law and jurisdiction, and so and I see sort of looking down the line that's not going to change much overnight. The impacts of those European laws, I think, in the sort of mid to long term, as we take back our sovereignty over the laws and whether or not we decide to follow whatever decision are taken in Europe, that will be yet to be seen whether or not our judges will agree with any decisions that come out of the European Court. I think probably in the long term, the biggest impact is just going to see how it translates for businesses. And so sort of from a negative point of view, you could be saying that there may be a lot of businesses going into difficulties, especially those that were reliant on European customers, difficulties with being able to sustain those orders, being able to meet orders if we have problems with getting through customs. And if that leads to decline, it causes financial difficulties for those British businesses. And that could then translate into sort of more activity on the insolvency side, with companies either entering into some form of restructuring, like an administration or a company voluntary arrangement, or it could be that the business really has been impacted by Brexit, leading to it having to go into liquidation. And I think a change as big as Brexit, we'll see an impact in that sense on some British businesses.
I don't take this the wrong way, gents. I don't fully understand all of the implications that are coming up towards the end of March. I try and keep on top of things, but I'm looking to you, and I'm looking to the press and people like that to sort of point me in the right direction. Are there lots or too many different opinions or too many different ways of looking at what's going to happen in a month or so's time? Do you find it confusing yourselves? Or is it something that you've gone, right, this is going to happen then, which means this, this and this?
I think it is confusing because we don't know what is actually going to happen. I mean, at the moment, the law states that we leave the EU on the 27th of March, is it?
Yeah.
If nothing else changes since then. Now, what impact will that have? Again, we'll have to wait and see. It might be that it's knock-on effects, as Stephen, you were saying, confidence and things like that. Is that going to affect the markets? I mean, housing markets, another one. Or is there going to be a deal in place which is then going to actually set out what's going to happen? But then again, that could have other effects. So I don't think
we just have to see.
We know much better.
I don't think the government even knows what's going to happen, do they? That's why we're in the situation we're in.
I mean, it's unprecedented, isn't it? I mean, the EU has been, fundamentally part of the legal framework of this country and the trade, biggest trading partner, and all of a sudden that's being, whipped out from under the carpet. No country's ever left the EU before. It hasn't happened before, so it's uncharted waters, isn't it? Really. So
that's right. And then
who knows? Having
that one land border, of course, between Northern Ireland and Ireland, that's effectively the sticking point, isn't it? So I don't fully understand all the implications there. Having customs checks or different currency one side of the road to the other. Right, shall we begin this evening's legal hour with some questions? The first one is from Barbara, and it is a dispute, Stephen. So are you ready?
Go for it.
Okay. I have a query on behalf of my nephew. He recently has bought a house, and there is a huge tree which is approximately 35 feet high that stands over half of his garden and half of his neighbours'. The trunk is literally slap bang in the middle of the border. It blocks out nearly all of the daylight, so he wants to cut some of it down. But they have said if he does, they will take legal action. Do you know what the law is around this, please? Thank you, from Barbara.
Unfortunately, it's probably outside my area of speciality. Trees and border disputes, very much a property focused question. But that, as always with things, it's not uncommon that I'll get a call during the day with something similar to that, and it's very much about being able to signpost that query to the relevant individual. Now, fortunately at Thursfields we do have specialists that cover a range of disciplines, and property, both commercial and residential property is within that speciality. So it's certainly something that I know that the firm could assist with. From a purely practical point of view, I can sort of understand the concerns on both sides of that dispute. That your listener's nephew who has recently purchased a property, obviously he wants to enjoy the having his new purchase, and that enjoyment's been impacted by the light that was there from the tree. And I suspect, on viewing the property, that it's something that didn't appear to be an issue, but now that he's moved in, it is. From the neighbours' point of view, they've lived there longer. They've been used to this sort of this wonderful high tree, and it's been a feature of their garden for some time. And there's concerns, for example, I don't know if the tree was being interfered with, could it die? Could it then fall over? Could it destroy their property? There's all sorts of concerns, I guess, from their point of view.
Sure.
I find typically with most disputes that that being able to have the sort of an honest conversation with them about their concerns, and understanding sort of if there's a way that we can get to a resolution without having to bring on board the lawyers. I'd leave it to my sort of colleague to sort of be able to explain it, the rights of the nephew in terms of if there are branches that are coming onto his property. Then I would have thought that he's entitled to do what he wants with in terms of lopping them off. But equally, it's probably an area that you do want to ensure you've got specialist advice, so you're not going to cause yourself more problems in the future.
Okay, I've got a question related to that. When people are having disputes and they say, right, I'm going to take legal action against you, what form does the legal action take for a dispute? Is it, you don't go to a small claims court or things like that. When they say, right, that's it, I'm going to call the lawyer.
Yeah.
What, is it a strongly worded letter from yourself?
Typically, it's that would be your next step. So when you get to the point where you're threatening to bring on board the lawyers, that paying all of that money to get involved in this dispute, it obviously indicates that it's serious, that it's not just a little spat. And that typically is where we'll get a phone call in the morning or during the course of the day of an irate individual, or it could be a employee or director of a company that have been morally wronged by the other party's action, and they are seeking advice as to what that legal right is. They feel aggrieved, but sometimes they don't know how to articulate what that claim is, and that's the purpose of coming to us. And it can be something as simple as it's a breach of contract, or as the question that you've just had. It could be something to do with the way that there's an interference with your right to enjoy your property. It could be substances are coming from one neighbour's garden into another, oil spilling over, things. All sorts of things can cause that grievance, and not having the familiarity with what your rights are and what your remedies are. That's the real reason, sort of seeking that professional legal advice, so that we can steer you down the right course. And it could be, as you say, if it's a small value dispute, something as simple as a small claims track. If it's hundreds of thousands of pounds or potentially reputational damage to your business, then it could be something that's completely different, a multi-track. If it's something that's harmful to your property that needs to be dealt with very quickly, it could be something in the form of what's called an injunction to stop someone doing something. So the different methods and what happens from that initial irate interaction can be a number of things, which we hope we can always either assist with, or, as I said before, it's signpost you to sort of the relevant speciality to help. Okay,
and of course that's thursfields.co.uk to get in touch with the team over here in Solihull, and they will be able to put you, Dawn, in touch with the right people over at the office. Correct? Okay, next one is for Ed. Ed, I hope this one is okay for you. Hello, I've not long bought my house and I want to make a will, but I have a daughter with learning disabilities and I want to leave it to her. Could you give me some advice about the implications about leaving it to somebody with learning disabilities?
Yeah, I think that's a good question, because I suppose when I write wills for clients, obviously it's that person who's telling me what they want to do, where it wants to go to, and actually quite a lot of the conversation I'll have with that client about writing their will or wills is thinking about the end goal, because really a will is just a tool to do a job, a means to an end. That's all there is to it, and the end point is the inheritance of the beneficiaries. So a lot of the conversation is about the beneficiaries themselves, so such as if there's any issues in terms of the beneficiaries, would it be a good idea or not for certain or all the beneficiaries to inherit, sums of money outright. And in particular, in respect of this question, it brings to mind what can we do in terms of any trust arrangements under that will. So there are certainly things that you can do within wills that can protect possibly vulnerable beneficiaries, such as potentially the one mentioned in the question. And really what it would be a case of doing is getting to grips in terms of the assets and what the inheritance would look like. The property was mentioned, but how we actually build that in or find a trust that works right for that. Sometimes things like inheritance tax comes into it, so it can be a balance between if there might be a trust that would be great in principle and suit the needs we have, but there could be a downside in that actually it's quite tax heavy, both in terms of initial inheritance tax, then ongoing trust management fees and things like that. So it's definitely would be worth your listener getting some specific advice on that, and I think that they would need to sit down with someone and actually talk through the ins and outs of it, but there's certainly potential to do something there.
Okay, so Dawn, if you want to get in touch, the website that you need to have a quick look at is thursfields.co.uk, and the contact details will be on there, and you will probably get through to yourself, Ed, wouldn't it, and have a chat?
Quite possibly, yeah.
Okay, brilliant stuff. Right, we're going to take a very short break to have some adverts, and when we come back, we'll bring Phil into play, if that's okay. So stay exactly where you are.
Thursfields is one of the region's most respected law firms with more than 120 years' experience. Winners of the Chamber of Commerce Excellence in Professional Services Award and High Growth Business of the Year Award. We have over 150 experts working across 8 regional offices, all dedicated to finding you real solutions. Get to know us better at thursfields.co.uk.
Solihullradio.com.
Hi there, I'm Joan Smith and I'm passionate about helping businesses grow. I'm an impartial broker working with experts in all areas of business support. I can support your business through different areas, for example, grants, loans, apprenticeships or training or general business advice. Get in touch via gintro.co.uk. Thanks a million.
Parkview in Shirley is a stunning residential development of 27 two-bedroom apartments. Modern, stylish and luxurious, the exceptionally high-quality properties are centrally located and next to the popular high street, with plenty of bars, restaurants and shops and an enviable view of Shirley Park. Parkview is an ideal home for first-time buyers as it's supported by the Help to Buy scheme and requires just a 5% deposit. Created to exacting standards, the apartments have allocated parking and cycle storage. With prices starting at £190,000, Parkview is superb value for money. For more information and contact details, visit parkviewshirley.co.uk.
You're listening to Solihull Radio.
Indian Dream on Dove House Parade, Solihull's premier family-run restaurant offering authentic Indian and Bangladeshi cuisine with fresh ingredients and creative chefs. They can provide bespoke dining experiences, eat in or take away. 0121 704 9058.
Solihull Radio.
Welcome back to Legal Hour. It is 20 minutes past 7. Thank you very much for downloading the Thursfields Legal Hour podcast. We have a team of solicitors in front of us. The next question that we've had in is Marie. Now, Marie needs some information on the process of how to go about getting a divorce. So this is a question for you, Phil. Can I read it out to you? Is that okay?
Yeah, please do.
I need to know the best way to get a divorce, and also... my husband is on drugs. We have children together, which I've stopped contact because of harassment and the emotional bullying. I've tried with the police to get help. I've got none. My car has been damaged and I've been threatened, but my kids want to see him, but I don't know what I'm thinking to do. I'm thinking of getting the social services involved, but I don't know what to do for the best. And that's from Marie.
Right.
Where do we begin?
There's 3 elements there. We've got divorce, we've got the harassment, and we've got the contact for Dad. Divorce, there are, well, at the moment, the law's staying the same, but the recent announcement from the Justice Secretary is that we're going to be having no-fault divorce in this country, which is excellent for us family lawyers. For the last 40-odd years, we've had a fault-based divorce system where one party's had to make allegations against the other or face waiting for a period of time. So hopefully that will all come to an end. I think they're looking to bring that through Parliament in the next session later this year, so that's all good. But currently, if she wants to get divorced, then she's going to have to make allegations of unreasonable behaviour or potentially husband's adultery if that has taken place. The alternative is to wait for 2 years or 5 years separation. Based on the information in her message, then certainly there appears to be unreasonable behaviour on his part due to the use of drugs and harassment and damage to her vehicle. So that I would think that that's a reasonably easy way of getting through the divorce process. In terms of the harassment itself, my view would be to go back to the police if that harassment is continuing, because it is an offence to harass her, and it's certainly an offence to cause damage to the vehicle. So I'm a bit unsure as to why there's been no action in that respect. On a civil basis, so that's outside of the police, she could apply to the court for what's called a non-molestation order. That is, in effect, an injunction, and that would, if granted, prevent husband from harassing her or certainly coming near the property or sending any communications, that kind of thing. In terms of the contact with the children, that's quite concerning given that the husband is on drugs. Certainly she's done the right thing in stopping the contact, because whilst the children do want to see their father, the issue is, of course, the safety of them when they're spending time with him. I'm not sure she needs to involve social services at this stage. She's taken the necessary precautions by stopping the contact, and ultimately it would be for him to seek some form of order from the court if he wanted to spend time with them, or failing that, for her to apply to the court to set a regime of contact providing it's safe. Okay.
Any more elements? Is it just a case of gov.uk/divorce? Is that where it all starts?
Certainly I'd say that she would need to take some specific legal advice, because there is certainly a lot more going on than just the divorce that perhaps she needs to... Well, she certainly needs to have advice on, because there's implications for the children. Certainly there could be safety issues if we're not careful. So I would suggest that she does take some legal advice rather than just visiting the website, because whilst the websites are quite user-friendly, they don't actually give individuals a lot of information, and people can certainly fall foul of the lack of information. Okay.
Right, the next two, I'm afraid, gentlemen, fall out of your spheres of remit. So if you could take... a good guess, if that's okay, and perhaps point them in the right sort of direction. In some ways, Stephen, it's a little bit more you than the other two gentlemen. I just need to know for your legal advice. As a tenant, if the landlord marries, does their spouse immediately become a joint landlord if their name is not on the tenancy agreement? Also, is there a limit to their visitations per year? And that's from Nikki.
Another property question, which again one of my colleagues would be able to assist. I think, from my point of view, there's the 2 points that have been raised there. I struggle to understand how the landlord, who I'm assuming is the sole owner of the property that that your listeners are a tenant of, how by him marrying the wife then becomes a co-owner. I can't see how that could happen without some form of transfer of what would be his sole interest to her. And it may be in time that they do go through that action, and then a renewal of the tenancy agreement results in the wife being a co-landlord to the tenant. But let's assume that none of that has happened. So I'm struggling to see how she would have any rights as a landlord without some variation to their agreement. On the second one, typically where I've seen leases or tenancy agreements, one of the landlord covenants is usually that there's quiet enjoyment, that the person who's renting the property is entitled to enjoy that property without the landlord constantly interfering, and so it would typically be a breach of that covenant if a landlord or an associate of the landlord, but kind of with the landlord's permission, is coming in and onto the property all the time. However, again, it's always going to be dictated by what was agreed in the tenancy agreement in there, and you may sometimes see provisions that allow the landlord or a landlord's agent to inspect a property to ensure that the tenant is complying with their obligations of keeping it in good condition, carrying out repairs. And so if there's something like that in the property, in the contract, then there may be a right for the landlord to go on and inspect. But again, you would expect that to be subject to reasonableness, and sort of multiple visits each month sounds to me as sort of as going beyond what anyone would agree in a tenancy agreement. But certainly, something again that my colleagues in property could assist with.
Okay, Thursfields.co.uk. Anything to add, gentlemen, or are we with the remarks of the last speaker?
With the remarks of the last speaker,
okay.
I think.
Is that the way forwards? Right, we're going to take a very quick break. The track that has been selected for Legal Hour by Jackie, our Noel, Dorridge and Bentley Heath correspondent, who unfortunately we may not be able to get to this week, but I will definitely play her track, is At 17 by Janice Ian. So Jackie, thank you very much for getting in touch with your request. So we'll just take a very quick break and then we'll be back straight after this.
I learned the truth at 17, that love was meant for beauty queens. In high school, girls with clear-skinned smiles who married young and then retired. The Valentines I never knew, the Friday night charades of youth, were spent on one more beautiful. At 17 I learned the truth. And those of us with ravaged faces, lacking in the social graces, desperately remained at home, inventing lovers on the phone, who called to say, come dance with me, and murmured vague obscenities. It isn't all it seems. It's 17. A brown-eyed girl in hand-me-downs, whose name I never could pronounce, said, pity please the ones who serve, they only get what they deserve. And the rich relation hometown queen marries into what she needs, with a guarantee of company and haven for the elderly. Remember those who win the game, lose the love they sought to gain, in debentures of quality and dubious integrity. The small town eyes will gape at you in dull surprise when payment due exceeds accounts received. It's 17. names were never called when choosing sides for basketball. It was long ago and far away. The world was younger than today, and dreams were all they gave for free to ugly duckling girls like me. We all play the game when we dare to cheat ourselves at solitaire, inventing lovers on the phone, repenting other lives unknown. They call and say, come dance with me, murmur vague obscenities at ugly girls like me at 17.
Back to Solihull Radio. My name is Geoff O'Brien. It is 28 minutes to 8 now here on hashtag Legal Hour on Tuesday Thoughts. Right, on the phone line now we are joined by Julie. Julie, are you there?
Hello, yes, I'm here.
Excellent stuff. Thank you for joining us here on Legal Hour. Now, your question, I know, is directed to Phil. So go ahead, Julie, and ask your question to Phil, our family lawyer.
Hi, Phil. Just a question with regards to some family law. My ex-partner has lived overseas for 6 years, and we've been split up for about 2.5 years. It's due to return to the UK, and it was basically to do with sort of maintenance payments.
Right.
He's paid sort of minimum maintenance payments, and I'm just not sure, because obviously he's living in Abu Dhabi, so obviously don't pay any tax and doesn't come in under any law. Whether I'm entitled to back pay for maintenance. Obviously, I've put what he's earning into the maintenance calculator now, because that's what he's saying he wants to use when he returns next month.
Right.
Basically, he should be paying a lot more than what he's paid me so far.
Okay, well, the initial problem you've got is that the Child Maintenance Service doesn't have any jurisdiction to deal with claims abroad, as you probably already know.
Yeah, I know that, yeah.
There is absolutely nothing you can do to get any more out of him than he's currently paying at the moment. When he returns to this country, it will be a different story. But they normally base their calculations on the inland revenue information that they have for his income. Now, I don't know how up to date that will be if he's been out of the country for 6 years, but they'll certainly want to see details of his income to be able to assess him properly.
Yeah.
So in terms of child maintenance, you can claim when he comes back. And as I say, they'll do the assessment on him and work out what he needs to pay you. Alternatively, I think if he's somebody who's...
So I'm not entitled to any back pay at all from what's not been paying?
No.
Right, okay. Because he's obviously coming back to the country with a large lump sum.
Well, that's a different story, because actually if he is coming back with a large lump sum, you do have the ability to make a claim under Schedule 1 of the Children Act for your children for financial provision.
Yeah.
So, and that's quite a technical area of law, but the reality is you can make a claim against him, depending on the size of the lump sum that he's bringing back with him.
Yeah.
You may well have a claim for you and the children there.
Right, okay. It's just because obviously he's only seen the children once a year, and then last year he's seen them 4 times in a whole year. So it's not like he's having any regular contact with them at all, because obviously, he's not in the country. Obviously, he wants to start having regular contact with them, but at the moment, he currently won't give me a date of when he's coming back to the country, so we can't sort of even start some sort of form of regular contact. So obviously, until he comes back into the country, that's when I would then need to go and see a solicitor, would I?
Yes, it would
start?
Be. I mean, with such a low level of contact, you'd need to regulate the contact starting again for the children's benefit.
I know,
it seems like you know that already. So certainly, if you get to find out when he's due back, I would say take some advice.
He refuses to tell me.
Okay.
So.
Well, then as soon as you know he's back, at that point, then you need to take some advice.
Okay, that's great.
Is that okay, Julie?
Yeah, that's great. Really appreciate that. That's brilliant.
No problems. I hope that's the answer that you were looking for from Phil.
That's great. Yeah, that's great. Thanks for your help.
No
Thanks,
problems.
Julie.
Thanks for calling in.
Bye.
Thanks. Bye. That was Julie. She was our first family law question for Phil. His area of specialism is, of course, family law. If you've got a question for Phil, why not get in touch? Right, the next one is for you, Stephen. Well, I say for you, it could be looking across at the other guys as well, the other gentlemen here. This one's from Fleur. And Fleur says, I need some legal advice as my ex-husband owes me £40,000. My daughters and myself will lose the house due to a repossession order, even though it's his debt. Please help. Thanks. Any ideas, Stephen?
So, slightly confused because you sort of mentioned it. It's £40,000. I'd normally ask if this was a client that had come into the office. On what basis is it that you'd lent him that money? He's not returned it, or is it something that a third party has sort of come to you? And you mentioned about losing the house, so that may suggest that there's a property, maybe a mortgage that was jointly taken out, and that the husband is no longer paying towards that. It's got to the point where the bank are now looking to take enforcement action, and had she received the monies from him, that they would have been able to pay off any lending to the bank. But there are lots of different sort of ways of tackling that problem, depending on the facts.
Could we imagine that it could go, as a Phil question, could this £40,000 be back pay for children?
That's what I was going to interject and say. She says ex-husband. There may well have been a financial order made at the time, in which case it might be a lump sum or a payment that's due to her under an order, in which case, yes, she can do something about it because she's got the ability to apply back to the court to get that money from him.
And if they lose the house due to a repossession order, where does that leave them? They obviously it's his debt. The mortgage may, like you say, Stephen, be in his name, and
So mortgage repossession, it can cover actually both mine and Phil's area. So a typical scenario is that a bank's taken enforcement action, and where you've got one joint borrower who's run off and typically would have been able to pay the mortgage. You've got the other joint borrower still living in the property. It's important that they go and seek that legal advice very early on. There can be ways of delaying or putting on hold the repossession action. Typically what I've seen in my experience is that people just ignore it and put their heads in the sand, and before they know it, they're getting a knock on the door from the bailiffs because a bank has already gone through the motions of getting the court order and then are seeking to enforce that. Whereas if an individual has gone to seek that legal advice before, they could get involved or take positive steps in the possession proceedings. And as Phil said, there may be very good reasons why they've not been able to pay money to the bank because of the financial order not being complied with, and it may be possible that they can buy themselves some more time to stop any sort of enforcement action with bailiffs going in trying to take possession by going off to court, getting the order, maybe taking positive steps to take monies out of the husband's bank account to ensure if he's not paying it directly that they get a bank to pay the monies or his bank to pay the monies to them. So, but I think the important thing is that the listener does go and seek that specialist advice as soon as possible.
Fleur.
So that Fleur gets that advice, so that if it is something like there's going to be a possession hearing soon, they can be best represented.
Okay. I hope that helps, Fleur. And, Thursfields.co.uk or head across to solihullradio.com and click the link and you'll be able to get in touch that way. Right. This is from somebody called Fallon. Now, Fallon is... when I first read your post, Fallon, on our social media, I didn't quite know who to pitch this to in our legal lineup here at the radio, but I will read it out. And gentlemen, if you have any ideas or ways that we could help Fallon, it would be really appreciated, even if it is just pointing her in the right direction. Hi, I saw your post regarding your legal advice. Mine is to do with a business that I started. I was misled a lot of the way. I know the lease has never been registered in my name at the land registry, and the salon has now ceased trading due to the high rates, including business rates, and I was told by the landlord's agent I was exempt. It's made me stressed out completely. they have served some kind of legal notice on me that they are going to apply to make me bankrupt. I'm under so much stress and so depressed from this. I have 2 children. I'm a single mum. I do not own my own home or car, and I believe bankruptcy will make my life even harder for my children and me. After receiving this notice, I spent the whole of Christmas stressed out, and my mind, I have just found out I've unfortunately lost my baby at 12 weeks. I'm certain this is down to the stress. Can you advise me at all? Sorry, gents, but do we have any advice on any of those points?
I can take that one, Geoff, and
Okay.
sorry to hear about the circumstances behind this particular question. Again, everything is always going to be fact-specific, but it sounds like that she entered into some form of agreement. She mentioned the lease, but it wasn't registered at Land Registry, and that may have resulted in her agreeing to a personal liability to pay, say, the rent at the property and other liabilities that once crystallised meant that there was a significant amount owed to the landlord, and methods of trying to obtain that payment through letters have failed. So the landlord has it sounds like, gone to the point where they've issued something what's called a statutory demand, which is usually the first start of what it becomes bankruptcy proceedings. And if they've issued that and it's not been paid within the 21-day period, then they may be going ahead to bankruptcy. Now, it's interesting, again, on the facts, because it sounds like she financially just is not in a position to be able to pay this. She has no assets. Therefore, it seems a bit short-sighted, the actions that the landlord's taken, because to obtain someone's bankruptcy, the costs of paying the official receiver are around about £1,000. So you're already down by that amount, alongside of whatever legal costs you're having to pay to get solicitors to go down this line. And so really, it's sort of, that's why I feel it can be short-sighted. As really, it sounds very vindictive that what they're trying to do, because they know that they're not going to get anything back. And unless they think that there are some assets hidden somewhere that a trustee is going to be able to recover, it seems just very much like a form of punishment. In relation to sort of the impact that that's had, obviously she mentioned the loss of her child. It's that's again going to be a specialist sort of area in terms of whether or not what's happened and the actions they've taken is sufficient to bring an action for that, effectively personal injury. Again, not an area for me, and possibly one that a specialist personal injury lawyer may be able to advise on.
Do you have anyone at the branch at your practice that is saying this is exactly who we need to point Fallon into towards? Or
yeah, we've got colleagues that deal with sort of clinical negligence type cases. So it may be one that they may feel from their sort of experience of that area that they can advise on sort of that psychological impact and any loss caused by that. But sort of from my perspective, it's that focus on the, do they have a valid cause of action? If I was acting for this individual, I'd be looking at, are they immediately entitled to go down that bankruptcy route? And there are questions that I would want to ask, especially about the representations made by the landlord's agent.
It almost seems like a sanction at that sort of level, doesn't it? If they know they're not going to get that back, and the bankruptcy, like you say, the bankruptcy seems almost like a sanction or punishment.
Yeah.
So Thursfields.co.uk will get you to that first point of call if you need some initial advice and guidance, and they will be able to point you in the direction of the correct people. Okay then, gents, it's coming up to our last question for this particular podcast. Sorry that we haven't used you very much, Ed. But
That's quite right. Happy to sit and listen and learn something different.
Wills and probate does not seem to be where everyone is thinking today. And again, this one I think is a sort of an amalgam of your knowledge, if possible. It seems to me a little bit like an employment question, but obviously there's some disputes. So, Stephen, if you've got some ideas, that would be great. My husband worked as a caretaker in a primary school over a year ago. The person that had originally employed him retired and the deputy head took over. He had no verbal or written warnings with regard to his work. He left to work in a full-time position. He didn't like that job and started applying for other jobs, and to cut the story short, he had 2 interviews withdrawn. The second one told him that the interview was withdrawn after speaking to this employer. We have just moved to Solihull and he was offered a position as a caretaker. The job offer was withdrawn due to unsatisfactory references. We obtained a copy of the reference and the previous employer stated in the section, "Do you think this person is suitable for the job?" She stated no. He seems to become unemployable due to her actions. Is there anything he can do? He's contacted his union, but they say there were no help at all. Regards from Sandra. Any ideas, or who should we point Sandra towards the direction of?
Well, in Solihull, that would be our employment specialist, Jade Linson, who I'm sure would be able to tackle this sort of issue on behalf of Sandra's husband. It does seem strange that the previous employer has sort of made that representation. They've probably been quite careful about it because they've not gone on to explain their reasons why they have made that comment that is now causing Sandra's husband difficulty. But certainly the issue of references and what you put in them is something that has been dealt with in numerous cases, and I suspect that's something that Jade can certainly provide some guidance as to how to take it forward.
Well, we can obviously email that question across to Jade, and if she does have any time over there at the practice, we can get that information back to you, Sandra. Gentlemen, thank you very much for joining us for your legal podcast.
Thank you.
Hopefully, anything that comes up over the next month or so as we move in towards the very famous March, and how it's all going to change in 8 or 10 weeks' time. We'll sort of keep our eyes open. Anything else from anybody else? I know you did say earlier on, Ed, that the fees are changing for probate, and a little recap on that.
Yeah, so in terms of my professional world, that's the big thing that everyone's talking about in the industry, other than the other B word that's being flagged about. And yeah, I think the basically it looks like we are going to be having a significant increase in probate fees for a lot of estates where individuals have passed away, and it's going to be on a banded scale rather than on a flat fee, and it's going to be determined by the value of the estate at death. In some cases it's going to be a very significant increase from sort of £155 to the most expensive end of the scale at £6,000. Wow. The details are still to be decided because it still needs to get through the House of Commons, and they're obviously busy in that particular house at the moment with other pressing matters. So the details such as is it going to be for applications to the probate registry after the 1st of April? Is it going to be from deaths that have occurred after the 1st of April, or the 6th of April indeed, has yet to be decided. But watch this space as we are.
Okay. Well, thanks for the updates. And, gents, when we'll see you again over here at Solihull Radio for the Thursfields Legal Hour. Thank you very much for listening. The next live show will be Wednesday evening, which will be the Solihull Rock Show with Jake. And you'll be able to get this podcast via our Podbean and on-demand service. So if any of your questions were answered this evening, or you would like to have the information from the gents from Thursfields, why don't you download the podcast, listen at leisure, and get in touch with us for the next legal hour. Thanks again for listening. My name's Geoff O'Brien, and you've been listening to Tuesday Thoughts. See ya.